Good evening, everyone. My name is Mackenzie Drake, and I'm the Artist Development Coordinator for the South Carolina Arts Commission. Thank you for joining us for our Artist Entrepreneur Incubator session of Copyright Basics with Laura Kaiser and Sarah Leader from the U.S. Copyright Office. Whether this is your first Artist Entrepreneur Incubator program or you've been with us before, this program series is designed to provide resources for South Carolina artists to level up their freelance businesses. We want you to learn and grow as much as possible, so we identify skilled instructors per topic to help you grow and sustain your arts business and practice. You're welcome to register for as many programs as you'd like, as many times as you'd like. At the end of the program, you'll receive a feedback form that we ask you to fill out. Your feedback is incredibly valuable and helps us to ensure that we're building a robust program schedule that helps you as artists. Completely optional, but to get a sense of the Zoom room here, you're welcome to introduce yourself, what city or county you may be coming from, and your artistic discipline in our chat. You're welcome to share this with everyone or just with us as presenters. As a Zoom webinar, we ask you to use the chat and the Q&A function throughout the program, and we do encourage your questions through that Q&A feature, and we'll collect those to address near the end of today's session. Now I'd love to introduce Laura and Sarah. Laura Kaiser is an attorney advisor in the Office of Public Information and Education at the U.S. Copyright Office. She amplifies the office's outreach efforts by presenting on copyright law for a variety of audiences. She also supports her colleagues with advice on legal accuracy and clarity when developing public-facing materials. Laura first joined the Copyright Office in 2022 as a paralegal with the Copyright Claims Board, where she helped to establish a new dispute resolution forum for copyright issues. Prior to joining the Copyright Office, she earned a JD from the George Washington University Law School and a BA in Comparative Literature from New York University. And Sarah Latier is a spring law clerk at the Office of Public Information and Education at the U.S. Copyright Office. She earned her undergraduate degrees in marketing and English from the University of Connecticut and is continuing her education at UConn School of Law, where she's pursuing a JD and a certificate in intellectual property. At UConn Law, Sarah has worked with intellectual property and entrepreneurship law clinic, assisting local entrepreneurs with trademark and copyright matters. Her passion for copyright law is rooted in her lifelong admiration for literature, theater, and creative innovation in the technology space. Thank you, and welcome, Laura and Sarah.
Thank you so much, Mackenzie and the South Carolina Arts Commission for inviting the Copyright Office to speak today. We're really grateful we were able to reschedule this presentation and get it on the program for you all. As Mackenzie mentioned, my name is Laura and I'm an attorney advisor at the Copyright Office, and law clerk Sarah Latier is here with me as well, and we'll be going back and forth through the presentation to give you all the information you need today. So this evening, we are going to start by going through some copyright basics for you all, including what our office does and what we're responsible for, as well as the building blocks of copyright, how to register your work with our office. We'll also talk about some enforcement options and, of course, take a look at our resources that we have available for the public. We are going to leave time for questions at the end, but as Mackenzie mentioned, feel free to jot them down, note them in the chat or Q&A, and time allowing, we will read through those and get to as many as possible at the end of the presentation. Just keep in mind, neither Sarah nor I can give any legal advice on specific situations, but we'll do our best to give you more information or direct you to some further resources to get your questions answered. And we've heard from Mackenzie that we have artists from a wide variety of disciplines, and I can see in the chat that you all have a wide variety of interests and artistic passions. So this is really, really great. This presentation is designed to be applicable for everyone, but we do have resources that are directed at specific types of creators, and we'll point that out as we go along. So with that, I'm going to get us started with some Copyright Office background. So the Copyright Office was founded in 1870, and we are housed in the Library of Congress here in Washington, D.C. The office's main purpose is to fulfill copyright's constitutional goals, and our mission is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright policy for the benefit of all. We also administer the Copyright Act, and that looks like a few different things. First, we are an Office of Public Record. So that means we make and maintain records that provide details on copyright ownership. And that includes our registration program as well as recorded documents, which encompass transfers of ownership. We also administer statutory licenses and we help manage and distribute royalties as required by law. Congress has also delegated authority to our office to develop regulations concerning many different areas of copyright. And those regulations cover a wide range of topics, including submissions to the office, such as the different types of copyright applications, some of which you'll hear about today, fees that are paid for our services, filings related to statutory licenses, FOIA requests, those are Freedom of Information Act requests, and much more. And these regulations as a whole provide the public with a well-functioning copyright system. And last, but certainly not least, we provide authoritative copyright information to the public by answering questions, by developing educational programs. That's part of why, of course, we're here today. And as the Office of Public Information and Education, that is central to our division's mission. So we do have a quick statistic on the right for you. This is the number of works that the office registered in fiscal year 24. It's over 400,000. And that includes works from the literary, performing arts, and visual arts categories. So with that background on the office, I am going to hand the mic over to Sarah now to introduce us to intellectual property generally as an area of the law and give us some of those building blocks of copyright.
All right. Thank you, Laura, and thank you, Mackenzie. Super excited to be here with you all tonight. So before turning to copyright specifically, it is helpful to situate it within the broader intellectual property framework or ecosystem. Intellectual property, or IP, refers to legal protections for creations of the mind. Copyright is just one of these categories of intellectual property. Under U.S. law, copyright protection arises when an author fixes an original work of authorship in a tangible medium of expression. Intellectual property law also includes protections for inventions through patent law, for brands through trademark law, and for certain commercially valuable information through trade secret law, as you can see on the screen. So U.S. law recognizes these several distinct forms of intellectual property, and they each serve a different purpose within the IP ecosystem. Patent law protects inventions and discoveries, and this includes processes, methods, machines, and devices. There are multiple types of patents as well. Utility patents, for example, protect functional inventions and processes. Design patents protect ornamental designs for articles of manufacture. And a good example of this, I think, would be the design of an iPhone. And there's also plant patents, and these protect certain plant varieties. Well-known examples of patented inventions include early telephone technology and digital printing technologies as well. Moving on to trademark law, by contrast, it protects words, names, symbols, or devices that function as source identifiers for goods and services on the market. Familiar examples you may have heard of in trademark law include distinctive logos, such as the Nike check, brand names such as Coca-Cola, and other design marks used in commerce, like the Barbie pink, for example. Trade secret law protects commercially valuable information that derives its value from not being generally known, and that is subject to reasonable efforts to maintain its secret. Plankton really had managed to obtain the Krabby Patty secret formula from the Krusty Krab and then went ahead and used it at the Chum Bucket. This would be a very classic example of trade secret theft. In the United States, patent and trademark law are administered by the U.S. Patent and Trademark Office, commonly referred to as the USPTO. Copyright law is administered by us at the U.S. Copyright Office. So now with that framework in place, we can now turn to some more key aspects of copyright law in greater detail. All right. So copyright protection in the United States is grounded in the Constitution itself. In Article 1, Section 8, adopted in 1790, Congress was granted the authority to secure exclusive rights to authors and inventors in their respective writings and discoveries. So this provision appears in the Constitution even before the First Amendment and reflects a very early recognition of the importance of encouraging creative and intellectual production. The Constitution actually refers to the protection of works by authors and scientists. While the term scientist has a more specialized meaning today, the framers at the time used it broadly to encompass individuals engaged in intellectual and creative inquiry, including those working in the arts and letters. In that sense, the constitutional copyright framework was designed to protect a wide range of creative expression. Now, today, U.S. copyright law is codified in the Copyright Act found in Title 17 of the United States Code. The statute defines a copyrightable work as an original work of authorship that is fixed in a tangible medium of expression. Works of authorship can take many forms, but at their core, they must be created by a human author and fixed in some physical or digital form. These works include literary works, musical works, dramatic works, choreographic works, pictorial, graphic, and sculptural works, audiovisual works, and architectural works. And we'll explore these categories a little more in detail in the next slide. All right, so what classifies as a work of authorship and why does that classification matter? So copyright law does not protect ideas in the abstract. Instead, it protects certain categories of expression once they are fixed in that tangible medium. Title 17 of the United States Code sets out these categories in specificity, providing a framework for identifying the types of creative works that are eligible for copyright protection. One such category is literary works, and this is broader than the term may initially suggest. In addition to what we think of novels and poetry, literary works also include essays, instructional materials, and computer programs and coding. Another category is musical works, including any accompanying words. This protection covers the underlying musical composition, often represented as sheet music, as well as the lyrics. It is important to note that this category is distinct from protection afforded to recorded performances of music. Dramatic works, such as plays and operas, are also protected, including any accompanying music. Dramatic works are works that are typically created for the purpose of performance. Copyright law also protects pantomimes and choreographic works. This category includes certain forms of dance and movement, though not all movement qualifies. To be protected, choreography must meet specific requirements, and purely generic or commonplace movement, like a step ball change, fall generally outside the scope of copyright protection. We'll return to these limitations a little more on the next slide. Additional categories include pictorial, graphic, and sculptural works, which encompass a wide range of visual art, as well as motion pictures and other audiovisual works, such as short films, television programs, and video games. Sound recordings are protected separately from musical works. This category covers the fixation of a performance or other sounds, including recorded music, podcasts, and audiobooks. Last, but certainly not least, is my favorite. Title 17 also recognizes architectural works. Added to the statute in 1990, this category includes the designs of habitable buildings, along with the associated architectural plans and blueprints. The key point to emphasize on this slide is that copyright protection really does begin with the nature of the work itself. Once a work falls within one of these statutory categories and is fixed in a tangible medium of expression, it is automatically eligible for copyright protection. So now that we have discussed what copyright law does protect, it is also important to understand what copyright law does not protect and the reasons for these limitations. For one, copyright does not protect artistic styles. No individual, ranging from Picasso to Dali, owns a style such as Cubism, Surrealism, anime-inspired illustration, or minimalism. Even when a body of work is highly recognizable, copyright protection does not extend to the style itself. Instead, it protects the particular expression embodied in a specific drawing, painting, sculpture, or digital file. Similarly, copyright does not protect techniques or processes. Methods for applying paint, using particular brushstrokes, or modeling objects in three-dimensional space are not in and of themselves protected. The resulting work, however, may be protected if it meets the other requirements for copyright. Similarly, ideas and concepts are also excluded from copyright protection. General ideas, such as creating a portrait, depicting a landscape, or imagining a character with certain traits, are not protected. Copyright protects the specific expressive choices made in realizing these ideas, including composition, arrangement, and visual or textual detail. Copyright also does not protect facts or real-world objects, so natural features, common symbols, and real people or places are not owned by any one person. And an author's original depiction or representation of these subjects, however, may qualify for protection. We did want to note that some of the subject matter that is excluded from copyright law may still be protected under other forms of intellectual property law. For example, certain functional innovations or design processes may fall within the scope of patent law, which, as we discussed, operates under a different statutory framework and serves a very different purpose in the IP's ecosystem. So while copyright and patent law can sometimes intersect, they do address distinct forms of protection within the ecosystem. The central principle to keep in mind is that copyright is designed to protect creative expression while still preserving access to fundamental elements needed for future creativity. It provides protection for individual works without preventing others from engaging with shared ideas, techniques, or subject matter. With that foundation in place, we have covered what does and what does not qualify as a work of authorship. But two additional requirements remain. So at this point, I'll turn things back over to Laura, who will discuss the originality requirement for copyright protection.
Thanks, Sarah. So yes, we have two additional requirements as part of the building blocks for copyright. Sarah went over works of authorship and what are not works. And now we're going to turn to originality. So you'll find many terms in copyright law. They'll have their usual everyday meaning that you might use the word original when you're speaking to, friends and family. And then, of course, in copyright law, it has a very specific meaning under the law. So usually we say for originality that there's two components to it. There is independent creation and sufficient creativity. So independent creation simply means that the work needs to be independently created by the author. It just needs to originate from the author. It can't be copied from another work. So in theory, you could have two works that are the same or very similar, and they can each have copyright protection as long as those similarities are just by chance and they're not the result of any copying. Now, the second requirement for originality is what we call sufficient creativity. And that means that the work needs to have at least a small amount of creative expression. So we like to say that while the bar is low for creativity, there is a bar to clear. So just to give you some examples of items that don't meet that bar, that fall below the bar for sufficient creativity, things like facts and data that wouldn't be considered creative enough to have copyright protection. Along similar lines, words and short phrases, names, titles, and slogans, those would not meet the creativity bar. This is similar to what Sarah was discussing with on the previous slide with what aren't works. Also familiar symbols and designs, as well as simple geometric shapes. Those kinds of things are not protected by copyright. So for example, a circle, a triangle, a star, those things wouldn't be protected because they're considered simple geometric shapes. And the last point here for originality is that what you create doesn't need to be particularly innovative. It doesn't need to be surprising. It just has to be more than simply mechanical, routine, or inevitable. So when evaluating whether something can have copyright protection, we don't ask, the value that the work has, the commercial success of it, how popular it is, how much effort went into making the work, how attractive it is, or any kind of impression or meaning that the author is trying to impart. These are subjective considerations, so they're not considered as part of these building blocks of copyright. The Supreme Court noted, that we want these subjective considerations not to be in the hands of a court. So that's why we have our building blocks as things that can be more objectively looked at. So now I'm going to turn it back over to Sarah to talk about our final requirement, fixation.
All right, so fixation means that a work must be captured, as you've heard us say, in a tangible medium of expression. So, in other words, it cannot exist solely as an unfixed idea. The work must be written, recorded, or otherwise embodied in some form that allows it to be perceived, reproduced, or communicated for more than what the law calls a transitory period. For example, artwork created through skywriting would generally not satisfy the fixation requirement because the medium would dissipate very quickly or shortly after its creation. However, if the skywriting was photographed from the ground or otherwise recorded, that recording itself would constitute a fixed expression for purposes of copyright law. The fixation requirement is significant because fixation allows copyright law to actually function in practice. So once a work is fixed, copyright protection can attach to that specific expression, giving rise to the bundle of rights associated with copyright. These rights, including the right to reproduce, distribute, and publicly display the work, depend on the existence of a fixed work. And Laura will address these rights in greater detail later. But before that, first we'll turn to the question of who qualifies as a copyright holder in the first place that is entitled to assert these rights.
Great. So, yeah, now we have the building blocks of copyright down. We can talk about some of these more advanced topics like who is a copyright owner and what are their exclusive rights. So, usually we say that the person who has created the work is the author of that work and they own the copyright in it, meaning that they own all six of those exclusive rights that we'll talk about more. In certain cases, though, the work might be made by somebody in fulfillment of an agreement or a contract, or they might be making it as an employee in the scope of their employment. And that's when we have something called a work made for hire. So, with a work made for hire, the author under copyright law and the owner of the copyright is actually going to be the employer or the person who specially commissioned or ordered the work. So there's two main categories for works made for hire. The first is when an employee is making something in the scope of their employment. So for that kind of analysis, we ask a bunch of key questions about the relationship between the employee and the employer. Like, where did they create this work? Was it in an official office? Was it in their home? During what hours did they create it? Was it on a weekend? Was it during their regular work hours? Was it part of their regular duties as an employee? What the nature of the relationship between the parties was? How was this person paid? So all of those kind of very fact specific questions go into that first category, whether this was an employee. And frequently, employers might have an employee sign a contract that's saying it's a work made for hire. So you just have to keep an eye out for that term when you see it. And we have more resources we can point you to that kind of go into greater detail about whether it's a work made for hire. The second category is a bit more specific. It only applies to 9 types of works that are set in the law, such as translations, illustrations, forwards to a book. They're all laid out in the law, and there really needs to be a signed written agreement for this type of work made for hire. There must be a contract that's signed by both parties, and it needs to say pretty clearly that it's a work made for hire. And then another way you can be a copyright owner is if you receive a transfer in writing. So maybe somebody has granted you one or more of the exclusive rights, and then you might own the copyright in a work. There's also, a way that you can own copyright in a work if you inherit it, by an operation of law like that, and then you'll own the copyright in something. Those are a little bit less common, but the main takeaway here is that if you created something, you're the author and the owner, unless you have that work made for hire situation to just keep an eye out for that in agreements. So now that we've covered more about ownership, we can talk more about the exclusive rights. So, as Sarah mentioned, we have 6 exclusive rights that the copyright owner has and can exercise. You can also license others one or more of these rights. So, we like to call them a bundle of rights so that you can kind of understand that they can be split off from each other. So, for example, you might give somebody a license to make copies. You don't have to give them the rest of the rights, the other 5. You can just give them that one right on a limited basis. So just to go through these in a little bit more detail, obviously making copies, everyone kind of understands and knows that one. Just keep in mind, it's not just physical copies. Of course, digital copies count as well. Also, the right to prepare derivative works. So, a really common example of this might be turning a book into a film. The film would be considered a derivative work from the book. And it simply means that there's some new creative expression that's been added to some pre-existing material. So, the film is going to build on and add additional creative pieces on the basis of the book and that creative material that's in the book. You also have the right to publicly distribute your work. So in this case, distribution and public have really specific meanings. So distribution is going to be the handing out to others, handing out copies, either through sale, some kind of transfer of ownership, or by rental, lease, or lending. And for the purposes of copyright law, the public is going to mean a substantial group of people outside of the normal circle of people you know, outside of family, friends, social acquaintances. That would be a distribution to the public. So if you're selling your poetry collection, you print it and you sell copies at a bookstore that's open to the public, that would be considered a public distribution. You also have the right to publicly perform your work. So this applies to certain types of works. Not every work can be performed. So for example, architectural works can't be performed, but we have in parentheses the works that would apply here. So for example, showing a film you made at an outdoor film festival, that's again open to the public. It's a public performance of that film. And then the right to publicly display your work, again, that applies to certain types of works. But like, for example, if you have a book and the pages are on display at an exhibit, that would be considered a public display. And then finally, we have the right to publicly perform sound recordings by digital audio transmission. Obviously, that's pretty specific and was added in later. It only applies to sound recordings. And you can think of this as like the right to stream music over the internet. So again, these rights are yours as the copyright owner. If you're the author and owner of your work, you have all of these rights as soon as you have those building blocks of copyright and as soon as those items are met. And if anyone does one or more of these things without asking for your permission with your work, it could constitute copyright infringement. So we'll talk a little bit more about enforcement options on a later slide, but I do want to cover also on the other side some copyright use and how to be a responsible user of copyright protected works. So how can you responsibly make use of a work if you want to incorporate someone else's work into your own, for example? So one way, and it may seem obvious, is to simply ask permission from the owner of the copyright. You don't have to have ownership completely transferred to you. Like I mentioned, you can ask for a license to use the work in one specific way. Maybe you just want to make a copy, maybe you just want to publicly display it. You could ask for permission and you might need to pay a fee, a license to use the work in that way. In addition to licensing and asking for permission, there are other ways that are prescribed in the Copyright Act itself, ways that people can make use of a work without asking for permission. The first on the list here is fair use. This is a concept that generally people who have some knowledge of copyright, they tend to know that term. It also gets used a lot in the news when certain important copyright cases come up. So you might have heard a little bit about a fair use already. I'm going to let Sarah dive into fair use more in depth on the next slide, but just be aware that is one of the exceptions in US law for using a work. We also have something called the first sale doctrine. So for this, the main takeaway here is thinking about when you have a used textbook, for example, the ability to give that used textbook to a friend, to sell it to a classmate, to give it to a bookstore for resale. That's all permitted because of the first sale doctrine. It simply means that you can resell or give away or dispose of a single copy that you've legally obtained and you legally own. And then we have statutory licenses. This comes up frequently for music. This is basically just prescribed licenses in the law. There, if certain requirements are met, there's like a set fee that people can pay, and then they don't need to ask necessarily for permission. They can just use the work. They just have to pay a set fee and meet certain requirements. And then we have our final two here. These are specific carve outs for certain institutions and certain uses. So for libraries and archives, and for educational institutions, for teachers, for use in face-to-face and online teaching, there's a lot of really specific requirements that these institutions need to meet and that the use needs to be. But there are specific carve outs in there for some uses so that libraries and archives can continue to do the work that they do. And then final note here, anything that's in the public domain is free to use. So you might be hearing public domain thrown out a bit this month in particular because January 1st is the day that works enter the public domain. So for example, our office publishes a blog around this time every year. I think our blog for 2026 dropped on New Year's Eve. And you can check it out and see the works that the office has chosen to highlight and that are entering that have entered the public domain as of January 1st. This happens every year. You might see other sources that also publicize various works. So our list is not exclusive. It's just the ones that we've chosen to highlight, and there's many more out there. But it's a good place to check. And just a reminder that, the public domain isn't a place. It includes not only works that have expired, not only works where the copyright duration has ended, but also it includes things that Sarah and I were mentioning earlier, works that aren't sufficiently creative. They don't meet that creativity bar. Those items would be in the public domain. Anything that's not covered by copyright law, and presentations like this one, because government employees that are acting in the scope of their employment, if they create anything, that is in the public domain. So keep that in mind. It's why you might see certain NASA photographs, for example, around on the internet because that's created in a federal government program, so it's public domain. So feel free to check out our resources, particularly our blog. That'll be in the links that Mackenzie sends after the presentation. But with that, I'm going to hand this over to Sarah to talk to you all more about fair use.
Thanks, Laura. So, as Laura mentioned, many of you may be familiar with the concept of fair use. So, fair use is a legal defense that may be raised in response to a claim of copyright infringement. Importantly, asserting fair use does not prevent a copyright holder from actually bringing an infringement action against you. Instead, fair use is evaluated by courts on a case-by-case basis. Courts assess fair use by applying a four-factor balancing test that is set out in the Copyright Act. Before turning to those factors, though, we do want to note that what follows is going to be a general overview of fair use. Fair use determinations are very highly fact-specific, and individuals with questions about a particular use should consult advice from a qualified attorney. The Copyright Office also, as Laura mentioned, maintains online resources summarizing fair use principles and recent case law for those interested in learning more. The first factor in this test is the purpose and character of the use of the work. Courts consider whether the use of the work is commercial or nonprofit in nature, with commercial uses often weighing against fair use. Courts also examine whether the use is transformative, that is, whether it adds new meaning, message, or expression to the original work. The second factor is the nature of the copyrighted work. Uses of highly creative works may be less likely to qualify as fair use than those of factual or informational works. Courts also consider whether the original work was published or unpublished, with unpublished works sometimes weighing against fair use in this analysis. The third factor is the amount and substantiality of the portion used. This includes both the quantity of the original work used and whether the portion taken represents what we like to call the heart of the work. So even a relatively small amount can weigh against fair use if it captures the most significant or expressive elements of the original work. The fourth factor is the effect of the use on the potential market for the work. Here, courts look at whether the new use substitutes for the original or interferes with the copyright holder's ability to license the work in the future. Because fair use requires weighing all four factors together, it does not usually lend itself to bright line rules that we can communicate here. So, as a result, consulting an attorney is often advisable when evaluating whether a particular use qualifies as fair use. Now that we have discussed exclusive rights, infringement, and fair use, we will briefly turn to the duration of copyright protection, so how long copyright lasts once it is secured.
Thanks. So, yeah, limited duration of copyright is a concept that goes back to the Constitution. So, as you can see here on the slide, we have the copyright clause that's part of the Constitution, and it says that authors can secure protection for their works for limited times. So, limited times here, that sort of translates into our duration rules and the fact that copyright does eventually expire. So, in general, under the current law, copyright is going to last for the life of an author plus 70 years after the death of that author. At that point, the copyright term expires and the work enters the public domain. If a work has multiple authors, so there's multiple authors involved, the copyright is going to expire 70 years after the death of the last surviving author. So this calculation does change slightly if we have work made for hire, which we discussed earlier, or if the work is written under a pseudonym, if it's a pseudonymous work, or it's an anonymous work, there's no author name identified, then the duration rules change slightly. It's 95 years after the work was first published, after that first publication date, or 120 years after the work was created, whichever expires first. So just important to remember those distinctions, and this applies to works created under the current law. For works that secured copyright protection under the prior law, the Copyright Act of 1909, the duration rules become slightly more complicated, and we have a duration circular that kind of goes through some of those rules at a really high level. But just note that anything created prior to 1978, you might have a slightly more complicated duration calculation, but anything created today, these are the rules that you see on the screen here. So now we've covered a lot of the building blocks of copyright ownership, exclusive rights. Now we can turn to copyright registration, and I'm going to hand the mic over to Sarah to get us started with that.
As we've noted throughout the presentation, copyright protection arises automatically once a work is fixed in a tangible medium of expression. Registration is therefore voluntary. However, while registration is not required for copyright protection to exist, it does have significant implications for how those rights can actually be exercised. Registering a work provides very important legal benefits, most notably in the area of enforcement. Registration is generally required before a copyright owner may bring an infringement claim in federal court or pursue a claim through the Copyright Claims Board, also known as the CCB. Without registration, the ability to enforce copyright rights is very substantially limited. Laura will discuss this point in a little greater detail on the next slide when we go over some enforcement options. Registration is a one-time process and does not require renewal. Once a work is registered, that registration remains in effect for the duration of the copyright. It is important to note, however, that registration does only apply to the specific work or works identified in the registration application. It does not provide blanket protection for all works that an author may create. So for creators who produce works in series or collections, the timing and structure of registration can matter as different rules apply depending on how works are grouped and submitted. It is also worth addressing here the third-party registration services, which some of you may have encountered. Some companies advertise copyright registration services for a nominal fee. These entities, we want to note, are not affiliated with the U.S. Copyright Office, and they do not confer additional legal rights or protections. At most, they submit the same application that an author could submit directly through the Copyright Office's online system. They do not accelerate the process of registration or alter the legal effect of registration when it comes to enforcing your rights. The U.S. Copyright Office is the only entity authorized to register works. Our hope is that in understanding this framework allows creators to make informed decisions about whether and when to register their works, whether to proceed directly with registration, or whether to seek legal advice based on how their works are being used. We would recommend for any copyright looking for sites ending in .gov when you're just looking for the Copyright Office's website. Or alternatively, you could contact our Public Information Office, PIO, who can assist in verifying the service being offered for registration and whether or not that does come from the U.S. Copyright Office. With that background on registration, we can now turn to some of the more practical reasons that artists do choose to register their works.
So, to go over some benefits of registration, as Sarah mentioned, this is voluntary. You don't need a certificate from our office to have copyright protection in your work, but it is a requirement if you are trying to file, let's say, a copyright infringement lawsuit in court. You do need the registration certificate from our office in order to do that, or you at least need a refusal to register from our office to file that lawsuit. In addition, registration also provides access to some additional remedies under the law. So, statutory damages is one example. Statutory damages are basically damages ranges that are set in the law. And because for copyright, sometimes proving your actual damages, your actual losses, can be a bit difficult. So, that's why there's statutory damages that have these set ranges. So, you get access to those if you've timely registered your work, and you would also get access to attorney's fees. And what we mean by timely registration, that just means that the work needs to be registered before the infringement started or within 3 months after the work was first published. Additionally, the registration certificate can also serve as evidence in court. So, if your work is registered before or within 5 years after the work is first published, that registration certificate can be used as evidence, and it creates a record of all the facts that are in that certificate, including the name of the author, the date the work was published, the date and nation of first publication, the title of the work, the type of the work, etc. And then we also, as I mentioned, are an Office of Public Records. So registration does contribute to the public record of creativity, and all the facts that you're putting into your application become part of that record. So this is actually helpful when you have others who are seeking permission to use your work. So in the registration application, there's a section called the Rights and Permissions section. And if you put in there the name of a person, either yourself or a representative or an organization, you can kind of direct people that are seeking to use your work to contact that person first for permission to use your work in various ways. So just keep that in mind also when you're registering, if you don't want certain personal information to end up in the public record, there are ways to avoid doing that. And we have some resources that can help guide you through those options. But the most obvious one that I like to use as an example is if you don't want to list your home residential address, you can use a PO box, for example, instead to keep your personal address out of the public record. So, as for what's required, it's pretty easy. It's three things for registration. One is the completed application, the application form. So, that can be done online, and we recommend that people do it online, and it kind of has to be done online for certain options. But we do have the paper form available if you need. And the type of form that you use simply depends on the kind of work that you're registering, how many works you're registering, and our registration portal can kind of walk you through these different options. In addition to the completed application form, you do need to submit a deposit. So the deposit copy is something that the examiners will look at and determine if it meets those building blocks of copyright and if it can be registered. This will be either the work itself or a suitable copy of it. And finally, the filing fee. And our filing fees range depending on what you're seeking to register. For example, if it's a single work, then it could be as low as $45 or $65 for our single or standard applications. And then if it's a group work of photographs, for example, those the cost goes up by a bit. But generally speaking, the process is designed to be cost effective and efficient for creators. And those are the three items that you need: completed application, deposit copy, and the fee, and that's it. So with that, I know that people are interested in enforcement options. So at a really high level, I'll just take you through a few of those options, a couple of which we've already mentioned in the course of the presentation. So the first is federal court. Copyright is federal law. So copyright infringement lawsuits can be brought in federal court, although as I mentioned, a registration from our office or a refusal to register is required. The second option, which I'll go into a little bit more detail next, is the Copyright Claims Board or the CCB. And this is a relatively new tribunal within our office, within the Copyright Office, where individuals and organizations can bring claims for copyright infringement. And it's designed to be efficient and cost effective, and you don't need a lawyer to use it. So I'll delve into that a little bit more next. Another couple of tools here, the Digital Millennium Copyright Act provides for a notice and takedown system. And you might have encountered this online. For example, if you see that YouTube has taken down a video, it might have been because somebody sent what's called a takedown notice. So under this setup, basically people that see content that's on an online service provider site like YouTube or Instagram or Etsy, if they think it's infringing on their copyright, they can send what's called a takedown notice. And the online service provider has a responsibility to remove that content. On the other side, the person who had uploaded that material, they can submit what's called a counter notice and say, oh, this was a mistake, I wasn't infringing, whatever the reason may be, and then the online service provider, like YouTube, could reinstate that content. So, and if there's a dispute between the two sides that goes beyond, there are other methods where that might enter the CCB, for example, or a court. But that's the general back and forth for the Digital Millennium Copyright Act. And then the final option here that I usually mention is recording your copyright with Customs and Border Protection. So after you've registered with our office, there is this option to record your copyright with CBP, and then they can stop infringing material at the border. So that's a high level overview of the enforcement tools, but I do want to spend just a couple of extra minutes talking about the Copyright Claims Board. I was the paralegal when the board was first being set up, so I'm pretty familiar with the processes, but I'll just go over it in general for you today. As I mentioned, it's a relatively new tribunal. It opened to receive claims in 2022. It is the first small claims tribunal for intellectual property in the U.S. And before we had the CCB, federal court was the only way. In addition to arbitration and negotiations, but the only way for lawsuits to proceed was through federal court. And federal court can be really time-consuming, expensive, procedurally complicated. Many people felt like they really needed a lawyer to be with them through that process. And this was a real barrier for small businesses and for individuals when they were trying to enforce their copyright. So the CCB was envisioned as a more efficient way for these small businesses and creators to resolve their copyright disputes. The cap on damages before the CCB is $30,000. And you don't need a lawyer to access it. Everything is online, so you don't need to travel to a court. You don't need to appear in person in DC. All proceedings are held over Zoom remotely. And it's pretty affordable. Participation is voluntary, so do keep that in mind. If you bring a claim against somebody, that party does have the option to say, no, thank you, I don't want to be part of this process, and they can do what's called opt out. They can opt out of the proceeding. If they do that, you do still have the option to bring the claim in federal court, but frequently we find that parties are staying in the process because it's this more efficient way to get these disputes resolved. And there is a way to also engage in settlement discussions before the CCB and have a CCB officer actually act as a moderator in those negotiation discussions. So it's a new, really great tool that we are encouraging people to at least be aware of as part of the copyright ecosystem. The CCB has a wealth of resources. They have their own webpage, ccb.gov. I'll just highlight two from this list in particular. The first is the handbook. So if you find yourself on the other side of a proceeding in the CCB, let's say you're the side that someone brings a claim against, or if you're interested in bringing a claim, the handbook kind of lays out in plain English and with helpful like visual graphics different stages in the proceeding. So whether you're bringing an infringement claim or a claim under the Digital Millennium Copyright Act for notice and takedown, there's a step-by-step process, and the handbook really kind of lays this out in a really easily digestible way for people. And if you're just interested in learning more about the CCB, I'd start with the introductory chapter. It kind of goes through at a high level, what the CCB is and why we're here. And then the second resource I just wanted to highlight is the pro bono assistance page. So even though you don't need a lawyer to participate in CCB proceedings, some people feel like they need some additional guidance and support, maybe with certain steps in the process. And then we usually advise them to take a look at that web page. On the web page, there is a list of law school clinics that have indicated they're willing to help CCB participants and some additional volunteer lawyers for the arts organizations as well around the country. And they frequently will be giving services on either a free or a low cost basis. And there's contact information on that page. So people who feel like they just need that extra support can turn to that resource. So with all of that, we're going to go through some of additional resources we have, and I'm going to actually turn it over to Sarah to talk more about our fairly new registration toolkit.
All right, so the toolkit was created as part of the office's broader effort to make copyright registration more accessible and understandable for creators, for small business owners, and whatever advisors that they may have in their corner. It presents copyright law and the registration process in a very clear visual format that is particularly helpful for visual learners. The toolkit includes practical guidance on some of the things that we touched on today, the fundamentals of copyright law. Additionally, it's how to prepare a registration, what to expect during the registration process, and other important considerations to keep in mind after registration. The office developed this resource to reduce common points of confusion and to help users engage more confidently with the registration system and copyright on an everyday basis. It really is an amazing resource, so I would highly recommend either scanning the QR code or maybe this will be in the list of resources that Mackenzie will send out tomorrow morning. Our team at the U.S. Copyright Office also includes the Public Information Office, whose amazing and attentive staff are available to answer general copyright-related questions. You may contact them a few different ways. You can submit the online form that you see on the screen, or by calling the number also displayed on the screen. For questions specific to the registration process, you may also request a registration walkthrough appointment. So during these appointments, a member of the team will guide you through the application form and explain basically how the process works. We do want you guys to note that while the Public Information Office is wonderful and can provide a lot of in-depth procedural assistance, they cannot offer legal advice or advise you on how to answer substantive questions related to your particular situation. So at this point, I'll turn things back over to Laura to wrap up the presentation.
Yeah, so just a couple of final notes before we turn to our question and answer portion of the evening. If you'd like to receive updates from our office, we encourage folks to subscribe to our Newsnet. You'll receive notifications when there's a new rule or a new event, for example. We are also active on LinkedIn and X, and we do have a really great YouTube page as well that breaks down in these short online videos some of the content that we talked about here today in a really easily digestible way. There's a video for fair use, for example, for the public domain. So if you just want a quick refresher on some of these concepts, the YouTube page is actually a really great place to start. And then I just wanted to highlight a couple of key upcoming dates and things coming up in the office. So on February 17th, about a month from now, we do have a new group registration option that's going to be coming out and is going to be effective. And that's the group registration for two-dimensional artworks. So this is particularly relevant for our visual artists in the audience today for pictorial and graphic art. You can submit up to 20 works. It's designed to be a new cost-effective option for visual artists, so we're really excited about it. Tomorrow morning, in the links that Mackenzie sends you, there'll be one for the webpage where we'll be updating it with additional resources as soon as this new registration option goes live. So you heard it here first. That'll be dropping on February 17th. So keep an eye out for more information on that. We also are celebrating the 50th anniversary of the 1976 Act this year. So we're very excited. The Copyright Act of 1976 is the current law, and the office is planning some really great things upcoming, particularly in our division in the Public Information Education Office. So if you subscribe to our Newsnet, I'm sure you'll be seeing some updates for the 50th anniversary in the coming weeks and months. And then finally, I had a quick plug for another webinar that the office is hosting. We're going to be doing as part of our Copyright Essentials series, which focuses on copyright basics for anybody who would like to register. We're going to be doing a session specifically directed at filmmakers, and that event is going to be on February 4th at 1 p.m. You can register online, and it'll be a really great session that does more of a deep dive for filmmakers in particular and what the common questions are that we hear, specific registration tips that we have for you all. And for your reference for Copyright Essentials, we have prior recorded presentations that were directed at writers, at musicians, for visual artists and photographers. So if you want to view any of the prior presentations that are more specific to your chosen art form, you can visit those recordings and take a look. You'll see myself presenting along with my former colleague. So take some time and take a look at those and check out the additional resources we highlight there. And with that, I really appreciate your time today. Thank you again to Mackenzie and the South Carolina Arts Commission.
Well, thank you all. If you do have any other questions, feel free to email me and I can probably direct them to you all if that's okay. Because I know that was a lot of information, but I will go ahead and end tonight's program. But I appreciate you all. Thank you so much.
Thank you.